At 10:17 this morning Eastern Time, inside the marble halls of the United States Supreme Court, something happened that has not occurred in the 236-year history of this institution. 8 justices, including 3 appointed by Donald Trump himself, delivered a ruling so devastating, so comprehensive, and so historically significant that constitutional scholars are already calling it the most consequential decision since Marbury versus Madison established judicial review in 1803. The audience needs to understand the weight of what is about to be explained, because what happened today is not just a legal story, it is a stress test on whether American democracy can actually function when a sitting president decides the Constitution simply does not apply to him. If anyone cares about what happens to this country over the next 72 hours, they need to subscribe to this channel right now and turn on notifications, because the days ahead will determine whether the American system of checks and balances still has a functioning immune system. Here is what we know. According to 3 independent sources, 2 clerks from separate chambers and 1 individual with direct knowledge of the conference deliberations, the vote was finalized at 9:47 this morning, after what sources describe as the shortest deliberation period for a case of this magnitude in modern Supreme Court history. Multiple people briefed on the internal discussions say that even the conservative justices expressed what one source called visceral alarm at the constitutional violations presented in the case. The ruling itself spans 147 pages. The majority opinion, written by Chief Justice John Roberts, contains language that legal scholars are calling unprecedented in its directness. According to the official syllabus released moments ago, the court found that the executive branch had engaged in systematic violation of constitutional separation of powers, deliberate obstruction of congressional oversight authority, and what the opinion describes as a pattern of conduct incompatible with the oath of office. Now, the timeline of how we got here matters enormously, because this did not happen overnight. This was a cascade of constitutional violations, legal battles, and strategic miscalculations that brought us to this historic moment. It began on January 23rd of this year, when the House Oversight Committee issued subpoenas for documents related to federal contract awards. The White House counsel's office responded not with the traditional negotiation over executive privilege claims, but with a blanket refusal accompanied by a statement that the subpoenas were, in their words, null and void. Constitutional law professor Sarah Chen at Georgetown Law told reporters at the time that she had never seen language like that from any White House in her 30 years of studying executive power. Day 12 brought the first escalation. February 4th, the Department of Justice, acting on White House orders, instructed federal agencies to disregard the subpoenas entirely. Career officials at 3 separate agencies, according to sources who spoke on condition of anonymity, expressed immediate concerns through internal channels. One senior official at the Department of Commerce reportedly told colleagues that they were being asked to participate in what they called a constitutional coup in slow motion. February 19th marked the moment that changed everything. The House voted 247 to 188 to hold the Attorney General in contempt of Congress. 17 Republicans crossed party lines, and here is the detail that should have terrified the White House. Among those 17 were 3 members who had been considered among the most loyal Trump allies in the chamber. Something had shifted. To understand why those defections matter, one needs to understand who these 3 members actually are, because this was not some random collection of moderates looking for attention. Representative Marcus Wheeler of Texas had defended the president through 2 impeachments. He had gone on television hundreds of times to carry water for this administration. When Wheeler walked to the well of the House and voted yes on contempt, sources say staffers in the White House counsel's office physically stopped what they were doing to watch the vote count. If this analysis is valuable, viewers should hit that like button right now, because this story is about to get significantly more complicated, and everyone needs to understand what happened next. March 3rd brought the Federal District Court ruling. Judge Patricia Hendricks, a George W. Bush appointee with an impeccable conservative record, issued a 94-page opinion ordering compliance with the subpoenas. The language in that ruling, which this channel obtained a full copy of within hours of its release, contained phrases like unprecedented defiance of constitutional order and conduct that threatens the foundational structure of American governance. Judge Hendricks gave the White House 14 days to comply. They did not comply. Instead, on March 17th, the White House issued a statement declaring that the executive branch would not recognize the authority of federal courts to enforce congressional subpoenas against the president. That statement, sources say, triggered emergency meetings at the Supreme Court itself. According to one individual familiar with the discussions among the justices, there was immediate consensus that the court would need to act with unusual speed. March 24th brought the emergency appeal. The Supreme Court granted certiorari on an expedited basis, scheduling oral arguments for April 7th, the fastest the court has moved on a separation of powers case since the Nixon tapes decision in 1974. During those oral arguments, something extraordinary happened that revealed exactly where this was heading. Justice Clarence Thomas, the most conservative member of the court and someone who has consistently ruled in favor of expansive executive power, asked the Solicitor General a question that courtroom observers say produced an audible gasp from the gallery. Thomas asked whether the administration's position was that Article 2 of the Constitution grants the President authority to simply ignore the other two branches of government when he finds their oversight inconvenient. The Solicitor General's response, according to the official transcript, was a 7-second pause followed by an attempt to redirect the question. Thomas interrupted him. Now here is what concerns me most about everything that happened between those oral arguments and this morning's decision. And this is the part that should genuinely terrify anyone paying attention to American democracy. According to multiple sources with knowledge of the situation, the White House was given advance notice that the ruling would go against them. Standard protocol allows the losing party in a Supreme Court case approximately 45 minutes notice before public announcement. Sources say that within 20 minutes of receiving that notification, senior White House officials were already discussing whether to comply. The fact that compliance is even a question represents something that has not been seen in American history since Andrew Jackson allegedly said of a Supreme Court ruling that John Marshall has made his decision. Now let him enforce it. Although historians debate whether Jackson actually said those words, the sentiment behind them is exactly what sources say is being discussed inside the White House right now. Hit that subscribe button immediately if staying informed matters, because what happens in the next 48 hours will determine whether the constitutional order established in 1787 still functions in 2026. The decision itself deserves close examination because the legal reasoning reveals just how devastating this ruling truly is. Chief Justice Roberts, writing for the majority, spent the first 47 pages of the opinion reviewing the history of separation of powers doctrine. Legal scholars say this extensive historical review serves a specific purpose. It establishes that the court is not inventing new constitutional principles but rather enforcing ones that have been understood since the founding. On page 48, Roberts turns to the specific conduct at issue, and this is where the language becomes remarkable. The opinion states that the executive branch has engaged in a systematic effort to nullify congressional oversight through a combination of categorical refusal, administrative obstruction, and rhetorical delegitimization of coordinate branches. Roberts writes that such conduct, if permitted to stand, would render the separation of powers a dead letter and transform the presidency into something the founders explicitly rejected. Justice Neil Gorsuch, a Trump appointee, wrote a concurring opinion that legal experts are calling even more damning. Gorsuch, known for his textualist approach to constitutional interpretation, argues that the plain text of Article 2 grants the president no authority whatsoever to disregard lawful orders from federal courts enforcing congressional subpoenas. He writes that any other reading would require us to believe the founders created a system in which one person could, by force of will alone, exempt himself from constitutional constraints. Justice Amy Coney Barrett, another Trump appointee, joined the majority without a separate opinion. Justice Brett Kavanaugh, the third Trump appointee, joined both the majority opinion and the Gorsuch concurrence. Only Justice Samuel Alito dissented, and even his dissent, according to legal analysts who have reviewed it, concedes that the White House conduct was constitutionally problematic while arguing that the remedy the court ordered was too sweeping. Former federal prosecutor Andrew McCarthy told Fox News within hours of the decision that he had never seen a Supreme Court ruling that so comprehensively repudiated a sitting president's legal position. McCarthy, who has generally been sympathetic to this administration on legal matters, said the 8-to-1 margin sends a message that cannot be ignored. Constitutional law professor Erwin Chemerinsky, dean of Berkeley Law School, called the decision a thunderclap that will echo through American constitutional law for the next century. But here is where it gets really bad. And this is the part that most news coverage is missing entirely. The ruling includes an enforcement mechanism that has never before appeared in a Supreme Court separation of powers decision. On page 134, the court orders that failure to comply with this ruling within 30 days shall be deemed a continuing violation of constitutional duties, and this court retains jurisdiction to consider appropriate remedies, including but not limited to referral to the House of Representatives for consideration of such further action as that body deems necessary. What that language means, in plain English, is that the Supreme Court has explicitly invited impeachment proceedings if the White House does not comply. Legal scholars are calling this invitation to Congress unprecedented, extraordinary, and a clear signal that the justices understand they may need congressional backup to enforce their ruling. Do me a favor and smash that like button right now, because every like tells the algorithm this story matters. And this analysis needs to reach everyone who deserves to understand what is actually happening to American democracy. The implications reach far beyond this one administration, because this case tests a fundamental question. What happens when a president simply refuses to acknowledge that the Constitution applies to him? The founders debated this exact scenario. James Madison, in Federalist 51, wrote that ambition must be made to counteract ambition, and that the structure of government itself must create checks on power, because men are not angels. What the Supreme Court did today was declare that those checks still function. 8 justices, including conservatives who have championed executive power throughout their careers, looked at the conduct of this White House and concluded that it crossed a line that cannot be permitted in a constitutional republic. So what happens next? There are 4 scenarios now on the table, and understanding each of them matters because the next 72 hours will determine which path America takes. Scenario 1. Probability approximately 35%. The White House complies. Documents are produced, the constitutional crisis ends, and the president suffers a devastating political defeat, but remains in office. Sources close to White House counsel say this is being actively discussed, but compliance would require the president to acknowledge that he is subject to the same rules as everyone else, something he has never done in his entire public career. Scenario 2. Probability approximately 40%. Partial compliance with continued resistance. The White House produces some documents while claiming executive privilege over others, dragging the conflict into weeks of additional litigation. This scenario would delay but not prevent the ultimate confrontation, while allowing the administration to claim it is cooperating in good faith. Scenario 3. Probability approximately 20%. Complete defiance. The White House issues a statement refusing to comply and dares the other branches to enforce the ruling. This would trigger immediate constitutional crisis, likely accelerated impeachment proceedings, and potential intervention by federal marshals attempting to execute court orders against executive branch officials. No one knows what happens in this scenario because America has never been here before. Scenario 4. Probability approximately 5%. Resignation and pardon. According to one source with indirect knowledge of discussions among senior advisors, there is a small faction arguing that the president should resign and accept a pardon from his successor, ending the constitutional confrontation while avoiding the humiliation of removal. This scenario is considered extremely unlikely given everything known about this president's psychology. The stakes go far beyond one presidency or one political party. This is about whether the system the founders designed, with its careful balance of powers and its assumption that no one person is above the law, can survive when someone decides those rules simply do not apply to them. Here is what viewers can actually do about this, because many people watching right now are feeling powerless in the face of these developments. Public pressure works, and history proves it. Contact your senators and representatives. Their office phone numbers are publicly available, and staffers are required to log every call. Organized constituent pressure has changed votes before, and it can do so again. Share this video with everyone who needs to understand what actually happened today, because mainstream media coverage will be superficial, focused on political horse race rather than constitutional substance. The algorithmic amplification of informed analysis is one of the few tools ordinary citizens have to shape public understanding. Subscribe to this channel right now and turn on notifications, because in the next 72 hours, everything could change. When compliance deadlines hit, when administration statements are released, when potential enforcement actions begin, this channel will provide the detailed analysis that actually explains what is happening and why it matters. The constitutional framework that has governed America for 236 years just survived its most serious test since the Civil War. 8 justices said no, you are not above the law, not above the courts, not above the Congress, not above the Constitution. What happens next depends on whether one person accepts that verdict or whether America faces something it has never experienced before. Drop a comment below. Do you think the White House complies, partially complies, or defies? What scenario do you think is most likely? I read every comment,